Before you file anything with USCIS this week, I need you to watch this video first, because as of March 1st, 2026, which is this Sunday, the cost of premium processing just went up across the board. And if you are sitting on a pending I-129, or you're about to file an I-140, or you are an F-1 student in OPT trying to get your work authorization faster, the difference between mailing your I-907 today versus mailing it Monday could literally be the difference between the old price and a higher fee that is now locked in for the next 2 years. But this video is not just about saving money on a filing fee, because the deeper question, the one that keeps coming up in our community over and over again, isn't just how much premium processing costs. It's whether it's worth paying for it all. And the answer to that question is not the same for everyone. In the next 15 minutes, we're going to break down exactly what changed, exactly what you'll pay, and exactly when paying nearly $3,000 for faster processing is the smartest financial decision you can make for your immigration future, and when it genuinely isn't. Welcome to USA Immigration Path. I'm your guide through the complexity of U.S. immigration policy. And as always on this channel, while social media is full of noise, we are looking at the official text. We are pulling the numbers directly from the Federal Register Final Rule published January 12, 2026, and the official USCIS fee schedule. No estimates, no guesses, just the verified facts. And before we go any further, the important reminder: I am an analyst guiding you through this system. This is educational content, not legal advice. Your specific case, your visa category, your employer's situation, your timeline, has details that only a qualified immigration attorney can evaluate properly. Please work with one. Now let's get into the numbers. Let's start with what exactly changed and why it changed, because understanding the reason behind this increase actually matters for how you think about it strategically. The law that governs premium processing fees requires the Department of Homeland Security to adjust the fee every 2 years to reflect changes in the Consumer Price Index for all urban consumers, what economists call the CPIU. This isn't a political decision and it isn't discretionary. It's a statutory formula. The last fee adjustment happened in February 2024. This new adjustment, effective March 1st, 2026, reflects a 5.72% increase in the CPIU from June 2023 to June 2025. That percentage sounds modest, but when you're applying it to fees that were already in the thousands of dollars, the dollar amounts involved are real and immediate. Here's the complete breakdown, pulled directly from the Federal Register Final Rule. For Form Y-129, the petition for non-immigrant worker, which covers H-1B, L-1A, L-1B, O-1, TN, E-1, E-2, E-3, and most other employer-sponsored non-immigrant categories, the premium processing fee increases from $2,805 to $2,165. That is a $160 increase. For Form I-140, the immigrant petition for alien workers covering all employment-based green card categories, including EB-1, EB-2, and EB-3, same increase. From $2,805 to $2,965, $160 more, effective Sunday. For Form I-129 petitions specifically requesting H-2B seasonal worker or R-1 religious worker classification, the fee goes from $1,685 to $1,180. That is a $95 increase, a lower tier because these categories fall under a different statutory designation. For Form I-765, the employment authorization document, and this applies specifically to F-1 students requesting OPT or STEM OPT extension, which is the population currently eligible for premium processing on I-765 filings. The fee increases from $1,685 to $1,180, again $95 more. And for Form I-539, the application to extend or change non-immigrant status, which covers F1, F2, J1, and J2 non-immigrant classifications requesting change of status with premium processing, the fee goes from $1,965 to $2,075. That's $110 more. Now here is the one critical rule about the timing of this increase, and it is worth repeating clearly because it is the source of the most common and most costly mistakes people make around fee changes. USCIS determines which fee applies based on the postmark date or the courier shipping label date of your I-907, not the date it arrives at the USCIS lockbox, not the date it enters their system, the date your package was sent. If your I-907 is postmarked February 28, 2026, with a clear date on the postmark or shipping label, USCIS will apply the old fee, even if the package physically arrives at the lockbox in early March. If your package carries a postmark or shipping label date of March 1st or later, the new fee must be included. And if you send the new fee but with an incorrect amount, even off by $1, USCIS will reject the I-907, return it, and your premium processing request never happened. You have to start over. You lose days. In some situations, you lose weeks. So the rule is simple. If you want the old rate, mail it today. Not tomorrow, not this weekend, today, now. Let's stop and do something that I think is genuinely more useful than just listing numbers. Let's talk about whether premium processing is actually worth it, because that question has a real financial and strategic answer that is different for different people. And too many applicants either reflexively pay for it without thinking it through or reflexively avoid it without understanding what it could cost them to wait. The honest starting point for this conversation is this: premium processing does not guarantee an approval. I want to say that clearly and upfront, because there is a persistent belief in our community that paying for premium processing is paying for a yes. It is not. What you are paying for is a guaranteed response from USCIS within a specific time frame. For most I-129 and I-140 categories, that time frame is 15 business days. For some I-140 subcategories, it is 30 business days. The response you get within that window can be an approval, a denial, or a request for evidence. If USCIS sends an RFE, the 15-day clock stops and restarts once your response is received. But here is the critical part. The 15-day timer forces USCIS to look at your case. On standard processing, your case can sit in a queue for a year or more before any officer opens it. Premium processing eliminates that queue entirely. So the real question is not whether premium processing guarantees a good outcome. It's whether the value of getting a definitive answer in 15 business days, rather than potentially 12 to 18 months or more on standard processing, justifies the cost. And the answer to that question depends almost entirely on what is at stake if you wait. Let's look at the facts, not the fear, by walking through the scenarios where the math clearly favors paying and the ones where it doesn't. The clearest case for premium processing is when work authorization is the bottleneck and a job offer is on the line. Think about a software engineer. Let's call him David. He's been offered a position at a technology company in California. The offer has a start date. The employer has filed the H-1B petition with USCIS under the cap-exempt pathway because the sponsoring employer qualifies. Without premium processing on the I-129, David is looking at standard processing times that can easily run 8 to 12 months at some service centers. His offer expires. The employer fills the position with someone else. The entire opportunity disappears. Now think about what that means in real numbers. David's offered salary is $140,000 per year. 12 months of lost wages while waiting on standard processing is $140,000. Against that backdrop, $2,965 for premium processing isn't an expense. It's the most cost-effective insurance policy he'll ever buy. The math is not close. But this is where it gets more nuanced, and most people don't think about this second scenario clearly enough. Consider what happens when an H-1B worker is approaching the end of their authorized stay. Standard H-1B status is granted for 3 years, with one 3-year extension bringing the total to 6 years. If your employer files a new H-1B extension petition and it's still pending when your current status expires, USCIS gives you what's called cap-gap protection. You can continue working while the petition is pending. But that protection is not unlimited, and the peace of mind that comes with having a clear, approved extension in hand, rather than operating under a provisional protection that depends on nothing going wrong administratively, is worth a great deal to most workers. Premium processing on that I-129 extension means you know where you stand in 15 business days. Standard processing means you're working under a legal gray area for potentially a year while your future is literally pending. For someone supporting a family, a mortgage, or dependence on derivative status, that uncertainty has a real cost that doesn't show up in a fee schedule. Now let's talk about the age-out scenario, because this is the one that I feel most strongly about flagging for families, and it's the one where the stakes are highest and the least discussed. Stop right there for a moment, because if you have a child who is a dependent on your immigration case, particularly a child who is approaching their 21st birthday, this section could be the most important thing you hear today. Under the Child Status Protection Act, commonly called CSPA, certain children of principal applicants can have their age frozen for immigration purposes under specific circumstances. But that protection is not automatic, and it is not unlimited. When a child ages out, when they turn 21 before their own immigration status can be secured, they typically lose the ability to continue as a derivative beneficiary on their parents' petition. They may need to start the immigration process entirely from scratch, in a different visa category, potentially from a different place in the priority date line. For a family from India or China in the employment-based backlog, that can mean a child who ages out effectively loses access to their own green card for years, maybe permanently in practical terms given their family circumstances. Now think about what premium processing on an I-140 petition could mean in that context. If securing an approved I-140 quickly helps protect or establish a priority date, or if it helps facilitate a concurrent I-485 filing that can be linked to CSPA calculations, the 2009-65 premium processing fee can be the difference between a child's entire immigration future being intact or derailed. That is a scenario where not paying for premium processing because the fee feels expensive is a decision that costs a family infinitely more than what they saved. Now let's also be clear about the scenarios where premium processing is genuinely less necessary, because honest cost-benefit analysis goes both ways. If you have no deadline pressure, if your current status is secure and authorized for another 2 or more years, if your employer is not pushing for a particular timeline, and if the standard processing time for your specific petition category at your specific service center is tracking within normal ranges, then standard processing is a legitimate choice. Not every petition needs to be on a 15-day clock. For an employer filing an I-140 for an employee who has a stable H-1B status, a recent H-1B extension approval, and a priority date that isn't moving for years regardless of how quickly the I-140 gets approved, standard processing may be perfectly appropriate. The money saved, $2,965 or $5,130 for a beneficiary and spouse, can go toward attorney fees, filing fees for other necessary forms, or simply staying in the applicant's pocket. Premium processing is a tool. Like any tool, its value depends entirely on whether the problem you're facing actually requires it. There's also one more thing worth knowing for F-1 students considering premium processing for OPT or STEM OPT I-765 applications. The fee at $1,180 is lower than the I-129 and I-140 tier, but it still represents a meaningful cost for a student who may not yet be earning a full salary. The processing guarantee for premium I-765 filings is 15 business days. Standard I-765 processing currently runs anywhere from 3 to 5 months depending on the service center. The question for an F-1 student is, what happens if your OPT isn't approved before your current F-1 status ends and you have an employer waiting on your work authorization start date? If the answer is that you lose the job offer, or that you cannot legally begin work and will need to defer your start date by months, then $1,980 is a straightforward investment. If your timeline is flexible and your employer has confirmed they will wait, standard processing is reasonable. Now let's make this actionable with 3 clear steps you can take right now. Step 1. If you are planning to file a premium processing request on an I-129, I-140, I-765 OPT, or STEM OPT, or I-539, and you want to pay the current lower fee, your package must be postmarked today or tomorrow, February 26th or 27th, 2026, at the absolute latest to carry a February date. Do not rely on regular mail for this. Use a courier service like FedEx or UPS, overnight or 2-day shipping. Keep your receipt showing the shipment date, and photograph your shipping label before you drop off the package. That shipment date is your legal proof of the applicable fee. If you are already past the February 28th window by the time you see this video, use the new fee amounts I've given you in this script. There is no grace period. Do not send the old amount on a March postmark. USCIS will reject it. Step 2. Before you decide whether to pay for premium processing at all, map your current authorized stay against the standard processing time for your specific petition category and service center. Go to uscis.gov and use the Processing Times tool. Enter your specific form type, category, and the service center on your receipt notice. Calculate how much runway you have before your current status or work authorization expires. If that window is shorter than the current standard processing time, premium processing is not optional. It is necessary. If you have more runway than the standard processing time shows, the decision is genuinely discretionary and based on your risk tolerance, your employer's timeline preferences, and any dependent family members whose situations are affected by yours. Step 3. If you are a parent with a dependent child who will turn 21 within the next 2 to 3 years, and you are in the employment-based preference category, talk to your immigration attorney this week specifically about CSPA calculations for your child's case and whether the timing of your I-140 approval affects their protection. This is a specialized analysis that requires someone who knows your exact priority date, your category, and the visa bulletin movement in your backlog. But the conversation needs to happen now, not when your child is 6 months from aging out and your options have dramatically narrowed. Immigration policies and fee schedules shift on a regular cycle in this environment. The next biennial premium processing fee adjustment will come in 2028, but fees for other form types, base filing fees, and processing priorities can change at any time through regulatory action, executive order, or operational policy shifts. The only way to stay ahead of changes that affect your case and your family is to stay informed before the deadlines arrive. Subscribe to USA Immigration Path right now so you don't miss the next update. Hit the notification bell so these videos reach you the moment something changes. And if someone you know is navigating an H-1B, a green card petition, an OPT application, or any employment-based immigration process, share this video with them today. The cost of being uninformed in immigration is almost always higher than the cost of the filing fee itself. We'll see you in the next one.